Chairman Grassley, Ranking Member Durbin, and members of the committee, thank you for the opportunity to testify on the Freedom of Information Act, FOIA. The FOIA statute is an amendment to the original public records provisions of the Administrative Procedure Act. As such, it is part of a series of checks to the growing federal bureaucracy. As the Supreme Court has explained, the basic purpose of FOIA is to ensure an informed citizenry, vital to the functioning of a democratic society, needed to check against corruption and to hold the governors accountable to the governed. Transparency advocates often quote Justice Brandeis's dictum that sunlight is said to be the best disinfectant, but less quoted is Brandeis's statement, electric light, the most efficient policeman. In our cloud and AI-based world of public information, modernized government should mean modernized transparency. I will focus my testimony on three critical areas where reform is needed. First, proactive disclosure requirements under FOIA. Second, pattern or practice claim review. And third, the effectiveness of the administrative process in reducing litigation costs. Proactive disclosure under the Freedom of Information Act obligates agencies to publicize information, notwithstanding the existence of a particular request, or when records are frequently requested. It is unclear, however, how to remedy agency failures to proactively disclose. Does FOIA provide that remedy, or does the Administrative Procedure Act? I believe administrative policy can go a long way in this area. For example, issued in 2019, Executive Order 13892 mandated public disclosure of a whole host of agency decisions. It was rescinded on January 20th, 2021, but would strongly serve the public interest if codified by Congress. Agencies generally comply with proactive disclosure requirements, including using searchable electronic reading rooms to post frequently requested records. But even greater transparency could be achieved by using technology to allow requesters to search for specific keywords within a set of documents, as relevant documents may be in the thousands, if not hundreds of thousands, of pages. Pattern or practice claims. A pattern or practice claim under FOIA is established when a plaintiff demonstrates the agency defendant has consistently failed to comply with FOIA's requirements, typically in the form of chronic delays and backlogs in responding to requests. Pattern or practice claims alleging systematic delays or denials are difficult to win. Violations of statutory deadlines can inform a pattern or practice cause of action, but past delays alone are insufficient unless they demonstrate a likelihood of future harm. In a world of increasing backlog with FOIA processing, agencies may strategically delay complex or politically salient requests to avoid political risk with disclosing documents. It is hard to show that such agency delay was the result of an intention to unreasonably delay processing versus a recognition that the FOIA workload takes time to process. Congress should clarify that when agencies engage in a pattern or practice of withholding documents or delaying processing, they're acting in an arbitrary and capricious manner. In addition to identifying intentional delay as arbitrary and capricious, Congress should also clarify that any such practice is itself the sort of rule of general applicability that must be publicly noticed in the Federal Register. Agency noncompliance with public notice requirements should entail some form of sanction or penalty on the agency. Lastly, administrative fixes and costs. Litigation remains a costly yet frequently necessary tool for FOIA requesters. According to the Department of Justice's annual FOIA litigation reports, the number of FOIA lawsuits has steadily increased over the past decade, largely due to agency delay or non-responsiveness. Congress sought to respond to these problems by providing a plaintiff with attorney's fees whenever the plaintiff substantially prevailed in a case. Yet such determinations give courts discretion to determine whether a plaintiff, typically in a summary judgment posture, won enough claims to have substantially prevailed. Due to such uncertainty, small organizations or individuals filing FOIA requests often end their process at the administrative stage. Congress should clarify the standard for substantially prevailing to mean whenever an agency is judicially compelled to take some action it refused to do during the administrative process. Concerning the administrative process, the Congress has established the Office of Government Information Services at the National Archives. This is a key resource for Congress to direct its attention to, allowing OGIS to do more than just simply notifying agencies of wrongdoing and to actually mediate disputes. Thank you.